A Supreme Court ruling could make a split-second choice inside your own home far more dangerous than most gun owners realize. And if you think your self-defense rights automatically protect you the moment a door gets kicked in, you need to hear this before you trust that assumption. Quick question before we continue. Are you subscribed? Because what I'm about to break down could help you avoid a life-changing mistake during a home entry, a traffic stop, or a police encounter that turns chaotic fast. Hit that button now, because these legal updates matter most before something goes wrong, not after. Here's what just happened in plain English, and why this topic is blowing up again. The case people keep pointing to is Kentucky v. King, an 8-1 Supreme Court ruling. It was not a Second Amendment case. It was a Fourth Amendment case, which means it was about search and seizure, or when the government can legally come into your space without a warrant. But here's the part nobody has talking about enough. When the court changes the rules for entry into a home, that can also change the real-world danger around self-defense. Why? Because your right to defend yourself and the government's power to enter your home can collide in one terrifying moment. So let me break this down for you. Police were chasing a suspect after a drug deal. They lost sight of him at an apartment complex. Officers went to a door, smelled marijuana, knocked, announced themselves, and then heard movement inside. They believed evidence might be getting destroyed, so they went in without a warrant. The Supreme Court said the entry could be lawful under the exigent circumstances rule, which is a fancy term for an emergency exception. In simple words, the court said if police did not create the emergency by doing something that already violated the Fourth Amendment, then the warrantless entry could still stand. Now, that sounds technical, but here is why it matters to you. Most gun owners hear warrantless entry and think one thing: my home, my castle. But the law is not that simple. The first thing you need to understand is this: your home gets the highest level of constitutional protection in most situations. But that protection is not absolute. There are exceptions. Emergencies are one, hot pursuit can be another, immediate danger to life can be another, and possible destruction of evidence can become part of the argument too. Here's the crazy part. In Kentucky v. King, the big fight was over who created the emergency. Did the police create it by knocking and announcing themselves? Or did the people inside create it by reacting in a way that suggested evidence was being destroyed? The majority said the police did not create the problem just by knocking and identifying themselves. Justice Ginsburg, the lone dissenter, warned that this approach could weaken the warrant rule in a serious way. Her concern was simple. If police can knock, hear movement, and then use that as the reason to go in, then the home starts to lose some of the protection the Fourth Amendment was supposed to give it. And that brings us straight to the self-defense issue. Imagine you're at home late at night. You hear pounding on the door. Maybe you hear yelling. Maybe you don't hear clearly. Maybe your kids are asleep down the hall. Maybe your dog is going crazy. In that moment, your brain is not doing a law school exam. Your brain is doing one thing. It is asking, is someone breaking in right now? That is where this gets dangerous. If the person outside is law enforcement, and if they enter under what they believe is a lawful exception, your armed response can be seen very differently than you think. Most people think, if someone comes through my door, I can defend myself first and sort it out later. But the truth is much harsher. If officers identify themselves, or if a court later decides the entry was lawful, your claim of self-defense may fall apart fast. And even if the entry was bad, using force in that moment can still put you in terrible legal danger. Here's what most people get wrong. They think an unlawful entry automatically makes any resistance lawful. That is not how this usually works in the real world. Your criminal case, your self-defense claim, and the officer's possible civil liability are not the same question. A bad entry does not guarantee your gun use becomes justified. In many places, using force against police, or even appearing to threaten police, can lead to charges, serious injury, or death, even before the legality of the entry is sorted out in court. So the practical lesson is not give up your rights. The practical lesson is know the difference between legal theory and survival. The Constitution may give you arguments later. It may not save you in the doorway. If you're finding this helpful, imagine what you'll learn in my next video about the exact words that can protect you when police start asking questions about your firearm. Subscribe so you don't miss it, because knowing what to say is just as important as knowing what not to do. Now, let me explain why this matters even more today than when Kentucky v. King first came down. Since then, the Supreme Court has also said police do not get some giant free pass to enter homes whenever they want. That is important. In Keniglia v. Strom, the court pushed back on a broad idea called community caretaking. In simple English, the court said police cannot use a general caretaking excuse to enter a home and seize guns without fitting into a recognized exception. That means the court has not erased the Fourth Amendment. Your home is still protected. Warrants still matter. Exceptions still have limits. But here is the tension. On one side, Kentucky v. King tells us police can sometimes rely on an emergency that unfolds after a knock and announce. On the other side, cases like Keniglia remind us the home is still special. Courts should not casually create new reasons for entry. So where does that leave you? It leaves you in the most uncomfortable place possible. In the real world, the legal line may be argued for months. Your decision at the door happens in seconds. Let's make this real with a hypothetical example. This is not a real case. It is just to explain the problem. Say you're cleaning a handgun at home. It is late. You hear pounding. You hear voices, but you cannot make out the words. You grab your gun and move toward the hallway. At that same moment, officers outside think they hear movement and believe someone is arming up or destroying evidence. They come in fast. You see shapes. They see a gun. You think you are protecting your family. They think they are stopping a threat. That is the nightmare zone where Fourth Amendment law and self-defense collide. Now, quick legal note. Now, this is educational information, not legal advice. Always consult an attorney for your specific situation. Second thing you need to understand, announcing that you have a gun during a fast-moving police event can make things worse unless you're doing exactly what local law requires and exactly what the officers are telling you to do. Some states have duty to inform rules, some do not. Some officers want immediate disclosure. Some want hands visible first and words second. That is why broad internet advice can get you hurt. The right move can depend on your state, the setting, and whether police already know you are armed. Third, don't make this mistake of thinking this issue only matters at home. It matters in cars, too. A lot of gun owners focus on burglary or home invasion, but many deadly force cases start with traffic stops. And that brings me to another important Supreme Court case you need to know about, Barnes versus Felix. In that case, the court dealt with a police shooting during a traffic stop. The key issue was whether courts should judge the shooting based only on the final split second when the officer said he saw danger, or whether courts should look at the whole chain of events. The Supreme Court rejected the narrow moment of threat idea and said courts must look at the totality of the circumstances. In plain English, that means the whole story matters, not just the final instant. Why should you care? Because that cuts both ways. It can help police shooting victims and their families when officers escalate a situation and then point only to the final second. But it also teaches you something important as a gun owner. Every move before the gun appears matters. Every command matters. Every misunderstanding matters. The legal story is built long before the shot. This is the part that shocked me when I first studied these cases together. Most people think rights live in neat little boxes. Second Amendment over here, Fourth Amendment over there, self-defense law somewhere else. But real life does not work that way. Real life is messy. You can have a Fourth Amendment question, a self-defense question, a use of force question, and a carry law question all in the same 60 seconds. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want clear, no-hype legal updates before the next big ruling drops. Click subscribe, because these cases move fast and confusion is expensive. So what should you actually do with all this? Let me give you the practical takeaways. First, stop assuming your self-defense rights are automatic the second a door opens. Context matters. Identity matters. What you knew matters. What police announced matters. What a reasonable person in your position would have believed matters. Those facts can decide everything. Second, have a home plan that does not depend on making hero decisions in total confusion. If someone is pounding on your door, your goal is not to win a legal argument in the dark. Your goal is to protect your family, get good information, and avoid turning uncertainty into gunfire. If you can move loved ones to cover, call 911 and verify what is happening, do that. If the people outside really are police, that 911 call may help confirm it. If they are not, that call helps too. Third, know your state's self-defense and duty to inform laws before you need them. Castle Doctrine rules are not identical in every state. Stand your ground rules are not identical in every state. Some states are far less friendly when the person at the door is law enforcement, even if the entry later becomes disputed. Do not build your safety plan around a meme. Fourth, if you ever survive one of these encounters, shut up early and get a lawyer. I know that sounds blunt, but it matters. After a terrifying event, people talk too much. They try to explain. They guess. They fill in blanks. They say things like, I thought maybe, or I kind of assumed. Those words get used against you. Ask for counsel. Give basic safety information if needed, then stop. Fifth, understand that bad facts beat good slogans. Saying, I know my rights, will not save you from a poor decision under stress. Training might help. Planning might help. Knowing your local law might help. Calm decision-making might help. Empty bravado will not. And here's one more point that almost nobody mentions. These cases also matter for how you store firearms at home. If there is any chance of a police welfare check, domestic dispute, mistaken address, or emergency response, think through how fast you can secure a gun, how clearly you can communicate, and how quickly a confusing scene could spiral. Responsible gun ownership is not just about marksmanship. It is about managing chaos. Most people think the legal danger starts after a trigger pull, but the truth is, the legal danger often starts with movement, words, and assumptions. That is why Kentucky versus King matters. That is why Barnes versus Felix matters. One case shows how entries can happen fast under claimed emergency conditions. The other shows courts should examine the full timeline when force gets used. Put those together, and you get one clear message. The law is finally admitting what gun owners should already know. The first 5 seconds of confusion can decide the next 5 years of your life. This information could literally become even more important as new court decisions keep shaping police power, self-defense claims, and gun owner risk. Subscribe now, because the next video explains the specific mistakes people make during police encounters that destroy otherwise strong legal defenses. So here's the bottom line. The Supreme Court's 8-1 ruling in Kentucky versus King did not erase your rights, but it did remind everyone that the government can claim emergency power faster than most people expect. And when that power collides with an armed citizen's split-second fear, the result can be tragic, expensive, and permanent. If this video helped you see the danger more clearly, hit subscribe and stay with this channel. I make these videos for one reason, so you don't learn these lessons for the first time in handcuffs, in a hospital, or in a courtroom. And please remember, this is general educational information only. Laws change, facts matter, and your exact situation needs advice from a qualified attorney in your state.